Vuga from Vuga Elder Law. I'm a certified senior advisor and an elder law paralegal. Today we're going to talk about the basics of estate planning, what we call Estate Planning 101. Estate planning consists of two parts. The part most people think about is the part of what happens to my stuff, my assets, when I die. The second part is, what if I don't die, but I need help or for someone to completely take care of me? What if I have a car accident and have traumatic brain injury? Or what if I develop dementia as I age? This part is actually more important than the part of what happens when you die, because it can affect your quality of life and the quality of care you receive when you can't speak for yourself. Let's start with the piece that comes first, and the part most people don't realize how critical it is to plan for. The what if I don't die but need help or need someone to completely care for me. In the state of Missouri, when you turn 18, you are legally considered an adult. From an estate planning perspective, that means your parents can no longer make healthcare decisions for you or handle your finances without your written permission. So if you have a child or a grandchild who is 18 or turning 18, this is something you should consider doing, because I can guarantee you they aren't thinking about it. An 18-year-old might think, that's fine, I can and I want to make my own healthcare decisions. But what if you have a car accident? What if you are unconscious and someone needs to make decisions about treatment or maybe surgery? By law, unless you've given legal authority to someone to make those decisions on your behalf, the emergency room doctor will be making those decisions. Again, you may think that's ridiculous. Of course the doctor will consult with my parents. Maybe, maybe not. We've all heard of HIPAA. And part of HIPAA is the protection of confidential handling of your protected health information. The Affordable Care Act enacted fines that start at $50,000 and go as high as $1.5 million a year for anyone who does not have written permission to discuss your health information. What that means is the nurses and doctors in the emergency room may or may not talk with your parents, depending on whether the individual or hospital has been charged with a HIPAA violation and fined. Having the ability to talk with nurses and doctors is extremely important if you have personal beliefs about being kept alive by artificial means, or if you have religious beliefs that involve medical treatment. Of course, as time goes on and more individuals and hospitals are fined, there will be less and less talking between healthcare professionals and families. Do you really want to take that chance? Having a HIPAA release gives permission for the nurse, doctor, or healthcare professional to talk to your family. However, it does not give someone the legal authority to make healthcare decisions for you. For that, you need a durable power of attorney for healthcare decisions. The durable power of attorney allows you to legally appoint someone to make healthcare decisions for you if you can't. Unlike the durable power of attorney for finances, the durable power of attorney for healthcare decisions only goes into effect when a doctor declares that you are no longer able to make your own healthcare decisions. Oftentimes, we'll see a HIPAA release embedded or part of the durable power of attorney for healthcare decisions. While they go hand in hand, you want them to be two separate documents. The durable power of attorney for finance is an equally important document. It too appoints someone to handle your finances if you are temporarily or permanently unable to do so yourself. The law sets forth 11 items that are automatically covered by a power of attorney. Things like create and fund a trust, make gifts, or appoint a guardian. Most people believe if they have signed a durable power of attorney, it means that the person they appoint can do whatever they want. The fact is, they can only do what the document gives them the ability to do and nothing else. There are different types of durable powers of attorney for finance. The first is a springing durable power of attorney. Springing means that it may not be used until a doctor declares that you are no longer able to handle your financial affairs. The other type is an immediate power of attorney. You can make all powers, including asset protection powers, immediate Or you can make them the simple powers like handling bank accounts and real estate immediately available, and more sophisticated powers like protecting assets springing. With these basic documents in place, your family can now make decisions for you and avoid the necessity of a guardianship for healthcare decisions and a conservatorship for financial decisions. Guardianships and conservatorships are a nightmare and something everyone wants to avoid. The biggest problem is the emotional and financial toll it takes on a family during a crisis situation. As we age, our legal needs change, just like our housing and medical needs. When you get married, or buy a house, or start a family, marks another important time to change your estate plan. If you haven't done so before now, it's extremely important when you get married to have durable powers of attorney for healthcare and finances prepared. The law says just because you're married doesn't mean your spouse can automatically make healthcare decisions for you. Just like when you turn 18, you must legally give your spouse written permission to make healthcare decisions or to handle your assets that are not in joint names, like life insurance policies or tax-deferred assets. You should also minimally have a last will and testament, or better yet, a trust. When you take your last breath, your durable power of attorney dies with you. Now your last will and testament, or your trust, takes over. Of course, your trust could already be handled by someone else who you've appointed to step in when you can no longer manage your assets. Now let's talk about what happens to my stuff when I die. The answer to that question depends on whether or not you've done estate planning. If you've done estate planning, either a last will and testament or some type of a trust determines who gets what and when. If you haven't done planning, the laws of the state of Missouri determine who gets what, and it may not be the people you want to inherit your money. For instance, if you're married and you pass without a will, you may think your spouse will automatically get everything. However, that is not what the law says. Let's start by talking about a last will and testament. A will names who gets your assets, who is in charge, the person known as your personal representative. A will only controls those assets that are in your name alone when you die. A will must go through probate. Probate is the legal process by which you transfer assets in your name alone to someone else upon your passing. By law, it must be open for 6 months. Typically in St. Louis County, a probate estate is open between 18 and 24 months. The probate court is in complete control of your assets. Probate is very public. I can go online to find out how much you have in assets, who you owe money to, and who's going to inherit your assets. If you want to avoid probate, you must have some type of trust. There are many different types of trust. For instance, if you have a loved one who has special needs, you will probably want to establish a special needs trust. This allows the person to receive an inheritance without disqualifying him or her from receiving government benefits. This is very important as there are many things a person needs that are not provided by government benefits. The most common type of trust is a revocable living trust. It avoids probate, it handles cognitive disability better than durable powers of attorney, and it makes things much simpler for your family to handle before and after your passing. However, everything in the name of a revocable living trust is countable for veterans benefits and Medicaid. In other words, a revocable living trust does not protect assets. Once you reach retirement age or are diagnosed with a life-limiting illness, you've reached another milestone where changes need to be made to your estate plan. Now is the time to think about an asset protection trust. The greatest threat to the assets you have accumulated all your life is the cost of needing long-term care for a long period of time. The average cost of a good nursing home is $8,000 or more a month. You might be able to afford that for a little while, but you probably can't afford that for many years. The benefits of an asset protection trust is that it stops creditors and predators. It can help you qualify for veterans benefit if you're a veteran or a surviving spouse of a veteran, and it protects your assets against the devastating cost of long-term care in a nursing home. I like to think of estate planning as building a house. A good, durable powers of attorney that gives the person you appoint many powers to do whatever they need and take care of you, and HIPAA releases are the foundation to your house. The walls are a revocable living trust, but a revocable living trust does not stop the cost of long-term care from stealing all your hard-earned money. Only when you put a roof on your house do you protect your assets for your future and the future of your family. That wraps up our video on Estate Planning 101. If you'd like to download the companion piece, the Estate Planning 101 booklet, fill in your email address below and it will be immediately available for you to download. There's also a glossary of estate planning terms that you're welcome to download. I probably haven't answered all your questions. Everyone's situation is unique. Everyone also thinks that they have more time than what they may. Please come in and visit with me. We'll sit down and we'll talk about your unique situation. We're not like a typical estate planning law firm. In fact, we'll have some fresh baked chocolate chip cookies for you. Thanks for watching the video. Please feel free to check out our other videos on YouTube, and I look forward to helping you get your ducks in a row.